Opticians versus Board of Optometry and Walmart versus Board of Optometry. Counsel for the appellants.
Thank you, Your Honors. I am Ron Lebowski, and I represent the National Association of Optometrists and Opticians, the appellant in this case with the Appellee Board of Optometry. This matter is before the court.
Is Walmart going to argue separately?
Yes, Judge.
Hold the time. In fact, reset the clock at 15 minutes, if you would, and tell us how, since this is...
I'm going to go ahead and take tentatively 7 minutes, Your Honor. Walmart will then take 5 minutes, and we're going to save 3 minutes for rebuttal.
All right. That'll be 7-5 and still saving 3 for rebuttal. I don't know. Can we give them notice at 7 or? All right. Well, let the light flash then for you at 7 minutes, and it'll be up to you to yield to your co-counsel over here.
Thank you, Your Honor.
Yes, sir.
May it please the Court. This matter is on appeal before the First District Court of Appeal following the issuance of a declaratory statement by the Florida Board of Optometry. The matter initially began pursuant to a request for, or a petition for declaratory statement filed by Victoria Haynes in August of 2004. Shortly thereafter, in October, the Board noticed and published the receipt of the declaratory request and set the matter for hearing. On November 12th, both the NAAO and Walmart moved to intervene in the proceeding, and on November 19th, 2004, at the Board meeting, the motion to intervene on the part of Walmart was granted by the Board. There was no decision with respect to the motion to intervene by the NAAO. At that time also, the petitioner, Victoria Haynes, requested an opportunity to amend her petition, which she subsequently did and filed with the Board on January 3rd, 2005. Thereafter, Walmart filed a motion to dismiss the petition, and on February 9th, 2005, the Board had a hearing, rendered various decisions, which were then subsequently placed into the final order issued May 4th, 2005. The final order that was issued addressed 5 areas of a lease that had been proposed by Walmart, allegedly. The motion to dismiss that had been filed by Walmart suggested to the Board that those issues were no longer relevant because the lease that was the subject of discussion had been modified in December of 2004 and submitted to Victoria Haynes for signature and pursuit of the continued lease situation. Victoria Haynes was already at the location that was the subject of the lease and was operating her business, and alleged and stated at the hearing that she had been there for 10 years. The first issue that was raised by the appellants, both appellants in this case, is that the 5 issues in the subject lease, which the Board entered an order on and found to be violative of Chapter 463 and Rule 64B 13-3.008, and that were concerned dealing with business plans, when the lessee would open for business, what coverage or provision of services would be provided, when the lessee would be absent from the premises to provide advance notice to the lessor, and various holidays that the store would not be open so that the location would not be operational on those days, were all found to be in violation of the various respective rules that are in the order. Each of those provisions did not exist in the lease at the time that the Board considered this. It was acknowledged by the Board that the issues that were raised and that were finally determined in the final order to be contrary to the rules were in fact moot. There's no dispute as this matter existed with the board at the time that it was considering and receiving discussion on this, that those issues did not exist between the parties. The appellant's position is that pursuant to the declaratory statement procedure, which is equivalent to a declaratory judgment, there must be an existing controversy between the parties in order for a court or a body to act and reach a decision.
Counsel, regarding this point, although you cite case law in your brief addressing declaratory judgment actions under Chapter 86 Florida statutes, how do you reconcile the declaratory judgment case law with the rule in declaratory statement cases that a statement is used so that a petitioner may select a course of action in advance?
The course of action, though, Your Honor, I believe that the case of Sutton at the 5th District Court, 654-1047, cited in our brief, reflects that there must be, in fact, a controversy or dispute between the parties in order to initiate the request and bring forth a decision from the board. So with respect to an advanced course of action, in this case, Your Honor, there was no dispute. Her advanced course of action was looking at the lease that had been presented to her in December and signing that with not any of these of concern. So her advanced course of action basically, and presented by her counsel, was basically, don't concern yourself with the specific facts of this case. Issue me an advisory opinion so that I can go out into the marketplace and make a determination of what I choose to do. That might be wonderful from a negotiation standpoint for Victoria Haynes, but it is contrary to the existing law in this state with respect to the issuance of a declaratory judgment. If the issues do not exist, Your Honor, the case law basically says that a court or this board should not be issuing an advisory opinion with respect to speculative set of events or speculative of facts.
Then why can't the board in this case infer that this issue may arise again in the future and thus address it now?
Because, Your Honor, I think that there was absolutely nothing in the record that it was going to, that it could infer that it was going to occur again. It was presented with a specific set of circumstances, and the case law and the uniform rules provide that there will be, in fact, a particular set of circumstances that affects, and the rule provides, that it will directly affect the business of the petitioner. That's stated from the uniform rules. And in this case, nothing that was before this board affected the business of the petitioner. There were no existing issues between the lessor and the lessee, and the uniform rules state that it's mandatory that they present facts that affect the business of the petitioner.
Is it your position that all of these provisions, which are outlined on page 3 of the final order, I guess paragraphs 9 through 13, these are the only provisions that led the board to find that there was both a statutory and rule violation?
Those were the only factual circumstances that the board concluded that there were, in fact, rule or statutory issues with respect to having those provisions in the lease.
What happened to the access to premises issue? Was it not pursued, or?
There were no decisions reached on any of those, Your Honor.
Most of those left out. Liability insurance was left out.
Excuse
the
me,
liability insurance, the additional named insured issue, those were left out.
None of those were ruled on by the board, even though they remained in the lease.
Okay, so the provisions we're dealing with are specifically the ones that are set out here at 9 through 13, which the amended petition states by almost identical sentence as to each. These are no longer in the lease as of December 21st.
They no longer existed in the lease at all, and it was agreed to by all the parties that they were moot, and in a review, the transcript will reflect that the board says, we realize these don't exist, but we're just going to accept them as true. I believe my time is concluded, Your Honor.
May it please the Court. My name is Rhonda Bogus, and I represent the other appellant and intervener in this action, which was Walmart Stores. If I can address Judge Lewis's question about how the argument of mootness squares with the issue to recur situation. This is an administrative proceeding, a petition for a declaratory statement, where the authority of the board is limited by the statute and by the administrative rule. It requires that it be relating to a particular set of circumstances. Now, it does not have, it may have some other people that may have similar set of circumstances, and that does not preclude it. But it requires a particular set of circumstances. The reason it does that is because in a declaratory statement, the statements of fact that are made in the petition are going to be assumed to be true, because the person who is requesting guidance is presumed to be in her best interest to basically set the facts straight. That's not what happened here. In fact, the issues on which she was, quote, seeking future guidance were not in her lease. They did not concern her. She has no interest in basically presenting to the board a set of facts upon which they can make a decision. This is totally hypothetical, and when the Florida Supreme Court talked about the declaratory statement proceeding and the administrative proceedings, it recognized that we still cannot deal with hypotheticals. This is not a hypothetical. This has to be something that affects the petitioner, because that's what keeps it honest, and it also allows her to actually give advice.
Counsel, I'll ask you the same question I asked the other counsel for the appellant. Why can't the board infer under the facts of this case that the issue may arise again in the future and thus address it now?
The board does not have the authority under the statute or under the rule to issue totally hypothetical situations. It has to apply to the petitioner's particular set of circumstances. Her attorney at the board meeting admitted these provisions are not in the lease. The original lease, the license agreement, was attached to the Walmart's motion to intervene. The revised lease is available. License agreement was attached to the motion to dismiss. It was before the board, and everybody recognized that these provisions were not part of her particular set of circumstances. By definition, that should end the inquiry. They have no authority. It has to be related to a particular set of circumstances. The board does have authority to rule on issues that might recur in the marketplace, but that's called rulemaking. That has different procedures, and it allows more people to get involved. In fact, the rule that's being interpreted here there was a rule challenge. It was ruled upon by the first DCA. There are provisions in that. If this had been a rulemaking procedure, there would have been opportunities for people to come in and say, look, all these provisions are economic, business reality decisions that have absolutely nothing to do with the practice of optometry. Walmart is in the business of making money, and when it allows someone to use part of their store, their commercial realities require certain provisions to be in place. That evidence could have been presented, and it could have been addressed. And if the board wishes to issue broad statements for recurring situations where they believe cause problems with the practice of optometry, that is the procedure they are to follow. They are not to use this subterfuge of basically having a declaratory statement on non-existent issues. And for example, business plan, that was ruled upon by the board in this situation. The lease only says you give us a business plan. It doesn't require certain things in there. There was an email that was before the board where they requested certain hours of coverage for it to be open. Walmart likes to have things open. It likes customers to have the opportunity. The part that they ruled upon was basically Dr. Haynes saying, well, what if it did this and what if it did that? It was not based on a particular set of circumstances, and it was not before the board on an appropriate procedure, and that has due process concerns. It has impairment of contract concerns. Walmart should not have to have decisions made on hypothetical provisions.
You would not be objecting if the provisions of the lease had remained intact and that the presentation to the board was the actual proposed lease by Walmart, right? That would be an appropriate declaratory statement?
Yes. If Dr. Haynes came to the board and said, may I enter into a lease with this provision? Now, we would not have an objection on their authority. We would be objecting as to whether those lease provisions have anything to do with the practice of optometry.
Right.
So that's the separate issue that basically we believe they also erred in finding that these commercial decisions had anything to do with the practice of optometry, but not as to the jurisdiction. This was a negotiation. Dr. Haynes didn't like some provisions of the lease. Certain of them, Walmart said, we're not taking them out. For example, the additional insured, which the board did not rule upon because it was withdrawn by her attorney. Others, they said, we don't care that much. We'll let you, we'll take those out because as a commercial interest, that's not what we're interested in. And I'd like to leave time for rebuttal.
Why were the provisions at issue here deleted from the updated lease agreements by Walmart?
Dr. Haynes had been at the Walmart store for 10 years. Some of these provisions, for example, opening for business and issues as to whether she would be available and how often she would be, really were not of a concern in this particular store. It was a business decision on Walmart that it wasn't worth fighting over on these things with Dr. Haynes. That's just the reality of a commercial reality. There are economic decisions that were made by Walmart in that manner. Thank you.
We'll allow each of you a little bit of time for rebuttal. Ms. Gustafson.
Thank you, Your Honor. May it please the Court, my name is Leanne Gustafson, Senior Assistant Attorney General. I'm representing the Board of Optometry in this case.
I got a couple of questions for you.
Okay.
If the board can rule on this, I mean, the procedural facts are undisputed here, I think.
Correct.
As far as how everything happened. If the board can rule on this, what's to prevent somebody like Dr. Haynes from going to, I don't even know if she's an optometrist or an optician. She's
an optometrist. The Board of Optometry has no jurisdiction over opticians.
Okay. If she went to an optometric convention in Omaha this summer, and one of the seminars was on big box leases. And they have people from Target and from Walmart and from Costco and all these big stores, and they got a bunch of leases. What's to prevent her from petitioning the day after she gets back, presenting the terms of all of those leases, saying these people either do business in Florida or may do business in Florida, and I want to know if these are legal or not? In other words, what I'm suggesting to you, I'm not sure I see the difference in that situation and this situation.
Well, I think that, actually I think the situations are pretty similar, because the only reason that we have any evidence that this could be a recurring problem for Dr. Haynes is that she's practiced at Walmart for 10 years. And if I can quote the motion for intervention by NAOO, members of NAOO operated...
So you're telling me that if she came back from the convention in Omaha, she could petition for a declaratory statement based on what other big box stores are offering optometrists in other states?
Not unless she were going to enter into a lease with them. But we would
Why would that make any difference?
Because we don't know that any of those particular big box cases are doing business in Florida.
Well, I'm assuming that they are.
Okay.
I'm assuming they're doing business in Florida, and I'm assuming she can allege that she's considering moving her practice over to Target.
I think that would give her authority to ask the board for a declaratory statement. I'm going to move to Target. This is what their lease says. And if the interveners are to be believed, all the leases have all these provisions in them.
No, I didn't make myself clear. I'm not saying this is what Target's lease in Tallahassee says. I'm saying these are representative terms that other stores in other states are using. I'm trying to take it a step away. And she wants an opinion on what another store in another state is using, all the while alleging that store is here in Tallahassee, and they may at some point adopt these contractual terms.
I see. Why? Because I don't think that at that point there's any evidence that the Target store in Tallahassee does have those terms.
Right. That's my hypothetical.
Yes. And the difference here is that we know that Walmart does have those terms. It's in the record that all of their leases have these terms in them, and they have had for 10 years until Dr. Haynes asked for this petition for declaratory statement. And all of the members of NAOO who operate 200 optical establishments in Florida, including big box lessees such as Lens Crafters, Inc., Pearl Vision, Cole Vision Corporation, and Vision Works, have very similar leases. That's what gave them standing to intervene in this case. So they established by intervening that Dr. Haynes is in a position. We have before us a record that she's worked in a big box for 10 years. She didn't have any intention of setting up an independent practice anywhere. She would likely go to another big box if, for some reason, Walmart would not offer her a lease that she felt comfortable with, and she would be facing the same lease terms by the admission of the interveners, or if she went to any other big box. Now,
Dr. Haynes' previous agreements with Walmart contained the issues in question.
I'm sorry, I didn't hear you.
Dr. Haynes' previous agreements with Walmart contained the provisions in question here.
Yes, that was the understanding of the board. There's also no evidence in the record that she signed the unmodified lease.
What if Walmart had a lease with somebody that required it to approve all new patients by the doctor? That would be a problem with the board, right?
Yes, sir.
Okay. Now, if they had that lease with some other doctor in another location, could Dr. Haney seek a declaration on whether that was appropriate or not?
No, because she cannot seek a declaration on the activity of the other optometrist.
But isn't that exactly what we're talking about here?
No, because she's talking about what she's going to do in the future, not what some other optometrist is doing.
But Walmart may in the future, if they've got a deal with somebody else, they could try to impose it upon her with Dr. Haney. So why not, from your perspective, seek a declaration as to what may happen with that some term in the future? What's the difference?
The difference is there is another optometrist involved, and it would appear from that question that she's asking whether or not that optometrist who is in that lease is acting properly by signing the lease with Walmart. The question is not.
You're saying it's not applicable to her set of circumstances, right? She's not substantially affected because it involves another doctor. But why isn't that exactly what was going on here?
Because she had a lease for 10 years. There was a modified lease that was presented to her. Now Walmart is saying that was a result of a business decision. In the briefs, they say they were forced to change it because of a decision of the board. She didn't sign that lease, and that lease only ran for 6 months. So there's no evidence that they weren't going to put those provisions back in. It appeared to the board that they had changed the provisions of the lease to avoid her getting a declaratory statement that they wouldn't like and avoid judicial review of that.
But, Counsel, it is possible that any future agreements between Walmart and Dr. Haynes may not contain such provisions.
Certainly it is possible, yes, Your Honor.
Wouldn't that be the appropriate time for Dr. Haynes to seek a declaratory statement if they did contain that his future agreements contain such provisions?
Then she would be back in exactly the same position that she is in now. She incurred the expense of having this thing filed with the board, having an attorney go with her to argue with it. And so basically, the Walmart would give a 6-month stymie her right to ask those questions, get that guidance, and make her start all over again 6 months later. And Walmart, who is not regulated, and NAOO, who is not regulated by the Board of Optometry, should not be able to interfere in Dr. Haynes' right to get some guidance.
But can't you provide the guidance through rulemaking, as they suggest?
Yes, Your Honor, and the board did initiate rulemaking with regard to this, but unfortunately, it's not in the record below. The board's considering that, but these particular provisions are new. The board can't foresee all of these things. They were asked a question about particular provisions of the statute, and what it appears in this case, if you look at all of the different issues that are in that lease, it appears that Walmart is trying to control the practice, trying to practice optometry. They want to offer optometry in their stores.
Why doesn't the final order mention the fact that the provisions at issue were deleted from the lease?
Because at that point, Dr. Haynes had not yet signed a new lease. And those were the questions that she asked.
My concern is very similar to what Judge Polston phrased. In fact, he actually had one of the questions about, I don't understand how you can distinguish this situation from another regulated practitioner. By the way, I don't know why this would be limited to optometrists. I don't know why doctors, dentists, and everybody else couldn't take advantage of this in the future and do one of two things, one of which is to pick up a practice of a competitor that they're not happy with, and in the guise of saying that they're getting ready to do this, ask for a declaratory statement on that. and the other of which is to use the state's declaratory statement procedure as simply a negotiation tactical tool when negotiating with a lessor or even with a potential competitor. Those are the two concerns that I have.
To address the first concern, it's because only the Optometry Practice Act has a prohibition against corporate practice. The other...
I understand that. I understand that, but by addressing this hypothetical, I don't know why it would be limited to a lease with an optometrist.
It's not limited to a lease with an optometrist.
Why couldn't you envision any number of circumstances that regulated professionals might get into where there's a questionable practice that they're not doing at the present time, and let them ask a question about it in order to, one, get in the business of a competitor and make threats to a competitor that they're violating the law, or two, to give them a tactical advantage in some sort of a negotiation with a hospital or something like that.
That may be a consequence of any declaratory statement, Your Honor. If you don't have an intervener coming in and alleging that that's what they're really doing, the board has no reason to believe that they are. And if the declaratory statement is properly asked proper questions, the consequences of it are not the board's problem. The board's duty is to look at that, give guidance to that person, how they use that guidance, whether it's in negotiations in the marketplace or competitive advantage, the board has no control over. If they do something illegal, they can be disciplined for possibly using it in a manner that would be contrary to their Practice Act. But the fact that they may use it for some reason that someone else doesn't like is not the board's issue.
Counsel, you agree with the statement that a declaratory statement is not appropriate simply to assist an individual in negotiating a lease agreement?
I do agree with that, Your Honor. I don't think if that were the sole reason that it was asked and it was clear that that's why they were doing it, and there was no legitimate question about application of statutes or rules to the circumstances of those negotiations, it wouldn't be proper. But if there are questions about whether or not your lessor is trying to control their practice of optometry, regardless of why you're asking the question, they're still entitled to that guidance. Their motivation is...
Is there any evidence in the record that Walmart agreed to not place these provisions in future leases with Dr. Haynes?
No.
Couldn't the board, to the extent it's concerned that Walmart or similar companies are trying to control practices, couldn't you go and find out what the current leases are that certain physicians that you regulate have with Walmart or others and determine if they are, in essence, in violation of the administrative rules by the board, then discipline the physicians in some way?
Well, they could, but the board doesn't have the resources, and neither does the department, to undertake that kind of investigation. And Chapter 456 specifically provides that the department can investigate cases when there's been a uniform complaint made. It can be either by an anonymous person or a non-anonymous person, and the department can also investigate if they have reasonable cause to believe there's a violation. Otherwise, neither the department nor the board have any authority to do that. If you don't have any further...
Thank you very much.
Yes,
Ms.
you're very welcome.
We'll set your rebuttal clock at 2 minutes. Each of you, you can divide that 2 minutes as you like, Mr. Levasky.
Just real quickly then, Your Honor, Judge Lewis, I think in response to your question, if the board wanted to infer by its choice, then I think its procedure is then to go into rulemaking. And I think that the case of DBPR versus Investment Corp., which is cited in the briefs, which discusses a DEC statement, and particularly an interesting quote where at 385 in that case, where it's discussing the small number of parimutuels that are affected by this DEC statement, and the fact that the agency then went immediately into rulemaking, I think that, and if you look at the transcript of the hearing, that's exactly what the appellants in this case basically were saying, is if you're going to adopt this broad statement that's going to affect any number of people, and particularly not the person that's standing before you, go into rulemaking and allow those parties to have their their process to
How much
deal with it.
opportunity in the declaratory statement process do you have for putting on evidence about the issues that Ms. Boggess raised, which is, I guess, the crux, which is whether, in fact, these provisions do constitute the practice of optometry?
Your Honor, I don't think you really don't have any. That's not, I don't think, the setting. I mean, I think, and as is reflected in this order, there's and as argued in, I think, in Section 3 of our brief, there's a adoption of a fact, X, and I'll apply Y, and I get Z. And there's no opportunity for the interveners, Walmart, or anyone to say, wait a minute, let's talk about how this affects the doctor, how it affects the practice. That's our argument 3, which is basically what the agency is doing here. If it had statutes that or rules that applied, was, as they argue, if you take 2 and 2, you get 4. And there's no opportunity to say, how does the process work, and is there an adverse effect on the practitioner? Is there an adverse effect on the patient? Is there anything of that nature? And that's our third argument, which is the agency is really improperly, it's an improper order because it's improperly applied the statutes and the rules under this proceeding to reach a conclusion that's impossible, if not only because of moot facts, just because of the facts don't apply to what the statutes that they've cited, in fact, or the rules, in fact, state. And they should do rulemaking at the best or the least. Thank you, Your Honor.
Thank you.
Your Honor, in fact, exactly what happened is the concern. As set forth by Dr. Haynes' attorney, it doesn't matter what's in Walmart's lease. We are going to confront this in the marketplace. We'd like some guidance, quote, help in negotiating this lease. That's what was going on here. That's it, pure and simple. The fact that these provisions were in past leases doesn't provide jurisdiction because declaratory statements cannot deal with the past. What was before the court, what was before the board was not in the lease, and the order which states it was in the lease was clearly erroneous. Thank you. I see my time's up.
Thank you, Ms. Boggess. Thank you all, counsel, for a very thorough presentation of this question.